that had you prove some type of special need in order to get a permit.
The co-chair of the Second Amendment caucus, Mr. Massey.
It is reported from the Rules Committee. Against any resolution reported.
They don't care about that fundamental liberty law-abiding citizens in this country enjoy.
California knows how to do these things well, and they know how to work around things so that they can just draft this new law.
Contrast that with what Republicans did to address gun violence and crime the last time they were in charge.
And there's been quite a few amendments. Well, the last thing to happen just happened yesterday.
California's SB 2 concealed carry ban. California's SB 2, a legislative milestone in the realm of concealed carry rights, has ignited a firestorm of controversy and apprehension among gun rights advocates. This far-reaching legislation, born in response to the Bruin decision, has stoked impassioned debates over its ramifications for the Second Amendment and the cherished right to individual gun ownership in the Golden State. In December 2022, SB 2 made its debut, and from the outset it was met with vehement criticism. Many considered it to be one of the most severe concealed carry bills ever proposed. It was seen by its opponents as an affront to the deeply ingrained gun culture of California, where the clash between urban and rural values on firearms ownership is perennially divisive. As SB 2 emerged onto California's legislative stage in December 2022, it sparked a whirlwind of controversy that rippled across the nation, drawing the attention of both staunch proponents of gun control and fervent defenders of the Second Amendment. This legislation, a direct response to the Bruin decision, signified a watershed moment in the ongoing battle over concealed carry rights in the Golden State. From the moment SB 2 was introduced, it became a lightning rod for intense debate and heated arguments. Critics wasted no time in labeling it as one of the most stringent concealed carry bills ever to be proposed. The sheer scope of its proposed restrictions sent shockwaves through the gun rights community, with many viewing it as a frontal assault on the deeply ingrained gun culture of California. The fault lines between urban and rural values on firearms ownership, which had always been a source of tension in the state, were suddenly thrust into the spotlight once again. Gun rights enthusiasts and constitutional purists quickly mobilized to challenge SB 2. Their main contention? That this legislation was a thinly veiled attempt to erode the Second Amendment, rendering it virtually impotent in the face of stringent regulations. They contended that California's unique demographics and urban density necessitated stricter regulations on concealed carry permits. To them, SB 2 was not an affront to the Second Amendment, but a pragmatic response to the complex and evolving challenges of modern society. Proponents of SB 2 maintained that the legislation was not designed to infringe upon the Second Amendment, but rather to strike a balance between individual rights and collective security. They pointed to California's distinct social landscape, characterized by densely populated urban areas, and argued that these circumstances required a more rigorous approach to concealed carry permits. In their view, SB 2 was a necessary tool in addressing the pressing issue of gun violence, especially in urban settings. They contended that safeguarding public safety was paramount, and SB 2 was a means to achieve this goal while respecting the broader framework of the Constitution.
If you did, you still couldn't use it because you couldn't go about your daily life without crossing through some type of sensitive location.
There's a hearing that you can't be at, your counsel can't be present, you haven't been charged with the crime.
Now today, as you all know as well, we're also marking National Gun Violence Awareness Day.
So in California, it was extremely difficult. California had to get rid of that good cause or just cause requirement.
Proponents emphasized that SB 2 did not seek to completely prohibit concealed carry permits, but rather aimed to establish a stricter and more uniform process for obtaining them. They argued that responsible gun owners would still be able to exercise their Second Amendment rights while ensuring that those with ill intent faced greater hurdles. California's SB 2 has undeniably ignited a contentious and emotionally charged debate. It has forced a reckoning between the values of individual gun ownership and collective security, with both sides passionately defending their positions. Whether SB 2 ultimately strikes a balance between these conflicting ideals or tilts the scale in favor of one remains a topic of intense scrutiny and ongoing legal battles. The origins and evolution of SB 2. The trajectory of California's SB 2, a bill that has evoked strong emotions on both sides of the concealed carry debate, born out of a response to the controversial Bruin decision, SB 2 has undergone a metamorphosis, marked by multiple amendments and revisions, ultimately arriving at its current form poised for legislative approval. In the crucible of California's political landscape, SB 2 experienced a transformation that few could have predicted. What initially drew sharp criticism and skepticism has, over time, evolved into a complex piece of legislation that seeks to strike a balance between public safety concerns and individual rights. The introduction and evolution of California's SB 2 have ignited an unrelenting debate that shows no signs of abating. This legislation, designed in response to the controversial Bruin decision, has become the epicenter of a contentious discussion that transcends state lines and delves deep into the heart of the Second Amendment and individual gun ownership rights in California. At its core, the debate surrounding SB 2 revolves around the fundamental question of balance. On one side are those who believe that stricter concealed carry regulations are necessary to safeguard public safety in a densely populated state marred by gun violence. They argue that SB 2 strikes this balance by introducing measures to ensure that only responsible individuals with proper training and background checks are allowed to carry concealed firearms. Conversely, opponents assert that SB 2 tips the scales too far, infringing upon the rights of law-abiding citizens to bear arms for self-defense.
Then the White House walked back that statement.
We filed formal petitions for rulemaking through the appropriate channels.
Of any semi-automatic assault weapon that was lawfully possessed before the bill became law.
Of 2022. Now, when it was originally introduced, it was the worst carry bill that I have ever seen.
They argue that the legislation's provisions are overly restrictive, making it nearly impossible for ordinary citizens to exercise their Second Amendment rights. In the court of public opinion and the hallowed halls of California's legislature, the debate rages on. As SB 2 inches closer to approval, the outcome of this contentious battle remains uncertain, leaving the future of concealed carry rights in California hanging in the balance. Challenging the good cause requirement. At the epicenter of California's polarizing gun control discourse lies the pivotal issue of the good cause or just cause requirement for obtaining concealed carry permits. This contentious prerequisite has stood as a formidable barricade, effectively obstructing the path for most individuals to exercise their Second Amendment rights. For years, this stringent condition remained a contentious emblem of California's stringent gun control measures, casting a long shadow over the hopes of many gun enthusiasts and advocates. However, the political landscape underwent a seismic upheaval with the watershed Bruin decision, a judicial landmark that categorically declared the good cause requirement as unconstitutional. In the aftermath of this groundbreaking ruling, Senate Bill 2 emerged as a harbinger of change, poised to usher in a new era by supplanting the good cause condition with an alternative set of criteria. This seismic shift in policy reverberates far beyond the narrow confines of concealed carry permits, encapsulating a broader recalibration of the state's approach to firearm regulations. Unsurprisingly, SB 2 has stirred passionate and often polarized debates across diverse segments of society, injecting a newfound intensity into California's ongoing conversation about gun control. The good cause requirement, as it existed before the Bruin decision, was a formidable barrier that frequently thwarted the aspirations of individuals seeking to exercise their Second Amendment rights. It mandated that applicants demonstrate a specific, compelling reason, a good cause, for carrying a concealed weapon in public. This requirement was a linchpin of California's strict gun control measures, drawing a line in the sand between the state's policies and those of more permissive jurisdictions. Critics contended that the stringent condition infringed upon the Second Amendment rights of Californians, effectively relegating self-defense to the realm of the privileged who could navigate its intricacies. The Bruin decision, handed down by the courts, struck at the heart of this good cause requirement. It asserted that the requirement violated the Second Amendment by unduly restricting the ability of law-abiding citizens to bear arms for self-defense. The ruling marked a significant departure from the previous legal landscape, reverberating with implications for the broader gun control debate, not only in California but also across the nation. While celebrated by proponents of gun rights as a victory for individual liberties, the decision simultaneously fueled concerns among those who advocate for stricter gun control measures, fearing that it could potentially erode public safety. SB 2 emerged as a pivotal piece of legislation. It sought to replace the controversial good cause requirement with a new set of criteria, reflecting a paradigm shift in the state's approach to firearm regulations.
And said he supports a ban on the sale of assault weapons, which there's no such thing.
And call on young people to continue leading efforts to end gun violence.
Tearing apart families and making our streets less safe.
But let's just say that you actually did get a permit under the original SB 2.
SB 2 became a symbol of change, eliciting fervent debates and impassioned arguments from all corners of California's diverse and ideologically charged landscape. Stringent background checks. SB 2 unfurls a tapestry of stringent background checks that serves as the linchpin of its concealed carry permit framework. Gone are the days when the phrase good moral character was enshrined in the legislation. However, the echoes of character scrutiny still reverberate within the system. The introduction of extensive background checks, including fingerprinting and comprehensive character assessments, signifies a marked departure from the past. It is a monumental stride toward ensuring that individuals entrusted with concealed carry permits are not only legally eligible, but also morally fit to bear such a responsibility. The essence of SB 2's background checks lies in their comprehensiveness. Fingerprinting, once considered an invasive intrusion, has now become an essential instrument for verification. It serves to confirm an applicant's identity and criminal history, leaving no room for ambiguity or falsification. Character assessments, though no longer explicitly tied to good moral character, continue to occupy a central position. Applicants are subjected to meticulous scrutiny of their past behavior, associations, and affiliations. This holistic evaluation delves into the depths of an applicant's history, aiming to discern any red flags or potential threats that may compromise public safety. The character assessment component of SB 2 introduces an element of subjectivity into the evaluation process. It demands a nuanced examination of an applicant's actions, potentially casting a wide net in search of any behavior or affiliations that may raise concerns. This nuanced approach ensures that those entrusted with concealed carry permits are not only law-abiding citizens, but also individuals whose actions and associations align with the broader principles of community safety. Critics argue that this subjectivity could lead to arbitrary decisions, but proponents contend that it is a necessary facet of the screening process, allowing for a holistic appraisal of an applicant's suitability. SB 2's stringent background checks represent a seismic shift in California's approach to concealed carry permits. Fingerprinting and character assessments have replaced the once controversial good moral character requirement, ushering in an era where eligibility is determined by a multifaceted evaluation of an applicant's history.
I think worse than that, sir. You will see millions of otherwise law-abiding citizens
Shall not be infringed.
Take all of the guns from all of the people. That's their goal.
Because Bruin said that that's unconstitutional, so they drafted SB 2, which was originally introduced back in December.
This recalibration, while not devoid of controversy, seeks to strike a delicate balance between individual rights and the imperative of public safety. As California continues to grapple with the intricacies of gun control, the impact of SB 2's background checks on the concealed carry permit landscape remains a topic of fervent discussion and analysis. Mandated training. The implementation of Senate Bill 2 ushers in a new era for individuals aspiring to obtain concealed carry permits in California. A pivotal facet of this transformation lies in the realm of mandated training. Under the provisions of SB 2, prospective permit holders face a formidable requirement: the completion of a comprehensive 16-hour training program. This mandatory training, while seen by proponents as a vital step in ensuring public safety, presents a multifaceted challenge. Firstly, the 16-hour training mandate is undeniably time-consuming. Secondly, there are financial considerations associated with mandated training. Completing a 16-hour training program incurs costs, which can include instructor fees, ammunition, range fees, and any necessary equipment. These expenses can accumulate, making the process prohibitively expensive for some prospective permit holders, particularly those from lower-income backgrounds. The financial burden imposed by SB 2's training requirement has drawn criticism, with some contending that it effectively curtails the ability of economically disadvantaged individuals to exercise their constitutional rights. Proponents of the mandated training component of SB 2 argue that it is a necessary safeguard. They contend that comprehensive training equips concealed carry permit holders with the skills and knowledge required to handle firearms safely in public spaces, reducing the risk of accidents or misuse. Advocates assert that the time commitment and associated costs are reasonable trade-offs for the enhanced public safety that this training can provide. Opponents argue that the training mandate imposes an undue burden on law-abiding citizens, infringing upon their Second Amendment rights. They contend that the right to bear arms should not be contingent upon the ability to invest extensive time and financial resources in training. These critics propose alternative approaches, such as streamlined training programs or voluntary training options, that would allow more individuals to access concealed carry permits without compromising public safety. SB2's mandated training requirement introduces a significant obstacle for individuals seeking concealed carry permits in California.
We're California, we're just going to go ahead and ban it outright, just in a different way that's going to be harder to legislate. So,
if we are referring to the ban on assault weapons, correct. Yes.
Let's see what is the most compelling thing to learn from that case. How many times was this gentleman...
So while everybody's distracted with New Mexico's ban on open and concealed carry,
the 16-hour training mandate, while intended to enhance public safety, poses challenges in terms of time commitment and financial burden. The ongoing debate surrounding this component of the legislation underscores the complex interplay between individual rights and public safety in the realm of firearm regulations. Carrying firearms in sensitive locations. The landscape of carrying firearms in sensitive locations undergoes a complex transformation under SB 2. While the legislation seeks to strike a delicate balance between individual rights and public safety, it introduces a web of intricate restrictions around certain places deemed sensitive. These restrictions, while not as prohibitive as they were in the past, continue to shape the contours of where concealed carry permit holders can lawfully bear arms. Places of worship, such as churches, once classified as strict no-carry zones, now fall within the purview of SB 2's revisions. While concealed carry is now permitted within these institutions, there are caveats. Permit holders must remain vigilant, as SB 2 still mandates adherence to the rules and regulations set by individual places of worship. This approach preserves a measure of discretion for religious institutions while acknowledging the evolving security concerns of the modern world. School premises, including college campuses, also experience a shift in the post-SB 2 landscape. The legislation eases the previous prohibitions, allowing concealed carry permit holders to navigate these spaces. However, there are lingering restrictions and nuances. K-12 schools remain off-limits for concealed carry, a measure designed to safeguard the safety of children. On college campuses, while SB 2 permits concealed carry, institutions retain the authority to establish their policies regarding firearms. This complex patchwork of rules and regulations adds an element of uncertainty for permit holders. Public transportation and airports represent another facet of SB 2's evolving framework. While some restrictions are relaxed, firearms remain prohibited in certain areas of airports, particularly those beyond security checkpoints. Public transportation, including buses and trains, see a mixed bag of regulations. While SB 2 opens the door to concealed carry on public transit, individual transit agencies maintain the authority to set their policies, leading to potential disparities in enforcement. SB 2 ushers in a new era of complexity in terms of carrying firearms in sensitive locations. While some restrictions are eased, a patchwork of nuanced regulations prevails.
SB 2 was California's answer to the Bruin decision because just like New York,
involved with shooting at people?
I'm not sure in total, but...
And in the House in this coming week. On Monday,
we are taking action. We are getting things done, and we are trying to save lives.
This approach seeks to balance the rights of concealed carry permit holders with the imperative of public safety. However, it also adds layers of uncertainty and variability that permit holders must navigate, reflecting the multifaceted nature of the ongoing debate over gun control in California and beyond. Political divides. In the tumultuous world of California politics, SB 2 has emerged as a lightning rod, igniting fierce partisan divides that have become emblematic of the state's legislative landscape. The Golden State, long a bastion of Democratic control, has seen the bill's progression through the legislative process marked by the stark polarization between the dominant Democratic majority and the vocal minority of gun rights advocates. As the Democrats flex their supermajority muscle in the state legislature, SB 2's journey has been a testament to the ideological chasm that exists between the two major political parties. Democrats, who have historically advocated for stricter gun control measures, have rallied behind the bill with unwavering support. Their argument is rooted in the belief that SB 2 will lead to safer communities by reducing the proliferation of concealed firearms. On the flip side, Republican lawmakers and gun rights proponents have vehemently opposed the legislation. They argue that SB 2 infringes upon the Second Amendment rights of Californians, curbing their ability to exercise their fundamental right to bear arms for self-defense. The clash between these two camps has been nothing short of a political battlefield, with debates turning impassioned and often bitter. In the midst of these contentious discussions, SB 2's passage has remained a largely partisan affair.
Today, Vice President Harris will also deliver remarks at John Lewis High School, where she will talk about
For the Biden administration about these issues we are discussing today prior.
The rule also allows certain legislation to qualify for the consensus calendar before the end of Congress.
And since most people weren't able to prove that special need,
the Democrats' grip on power in California has allowed them to push the bill through, even in the face of fierce opposition. The outcome of the vote has underscored the uphill battle faced by gun rights advocates in a state where their views are often drowned out by the resounding voices of the majority. Implications for concealed carry applicants. Navigating the labyrinthine landscape of SB 2's implications for concealed carry applicants in California presents a multifaceted challenge. This legislation, with its intricate web of provisions, stands as a formidable barrier for those seeking to exercise their right to bear concealed arms in the Golden State. One of the most prominent hurdles facing prospective concealed carry permit applicants is the sheer complexity of the legislation. SB 2 weaves a tapestry of regulations that demand a meticulous understanding of its intricacies. The labyrinthine legal language and procedural requirements can be daunting, often necessitating legal counsel to ensure compliance. As a result, the average Californian finds themselves grappling with a formidable bureaucratic maze, testing their patience and resolve. Can accumulate to a substantial financial burden. For many, especially those from economically disadvantaged backgrounds, this financial strain becomes an insurmountable barrier, effectively denying them their right to concealed carry. The legislation's restrictive nature further compounds the challenges faced by applicants. SB 2's stringent background checks delve deep into an individual's history, scrutinizing every facet of their life. This thorough examination, while intended to enhance public safety, can feel invasive and time-consuming to those seeking a permit.
Retired law enforcement, judges, and people of that nature.
Yesterday, Speaker Pelosi, speaking at an anti-gun rally in San Francisco, stated,
I have a general idea of what I would have said under that circumstance, but no, I don't.
That's what they did originally with SB 2. Now, SB 2's been bounced back and forth between the Assembly and the Senate.
Perhaps the most contentious aspect of SB 2 is its limitation on access to public spaces while carrying concealed firearms. The legislation designates numerous gun-free zones, including schools and government buildings, where carrying concealed weapons is prohibited. This restriction, while aimed at bolstering public safety, has drawn the ire of gun rights advocates who argue that it infringes upon their ability to protect themselves in a variety of settings. SB 2's implications for concealed carry applicants in California are profound. Its complexity, costliness, and restrictive nature pose significant challenges, potentially dissuading many from pursuing concealed carry permits. While the legislation's intent is to enhance public safety, its implementation has far-reaching consequences for those seeking to exercise their Second Amendment rights in the Golden State. Uniformity versus restrictions. The concept of uniformity in California's concealed carry permit process, as presented by SB 2, is an intricate and contentious one. On the surface, it may appear that the bill seeks to standardize the regulations surrounding concealed carry permits across the state, ensuring that every Californian undergoes the same rigorous procedures and meets the same criteria. However, upon closer examination, it becomes evident that this pursuit of uniformity comes at a cost of introducing a slew of additional restrictions, further entangling an already complex system. Proponents of SB 2 argue that uniformity is essential for maintaining consistency and predictability in the issuance of concealed carry permits. They contend that a uniform process ensures that individuals applying for permits are subjected to the same set of rules and regulations, regardless of their geographic location within the state. This, they argue, prevents potential loopholes and inconsistencies that could arise if individual counties were allowed to establish their own, potentially more lenient criteria for issuing permits. However, the pursuit of uniformity through SB 2 has raised concerns among those who staunchly defend Second Amendment rights. While they acknowledge the importance of a standardized process, they contend that the bill leans heavily towards restrictions rather than streamlining the system. By imposing stringent background checks, costly training requirements, and limiting access to certain public spaces while carrying concealed weapons, SB 2 erects formidable barriers for law-abiding citizens who wish to exercise their constitutional right to bear arms for self-defense. While uniformity can help eliminate disparities between counties in California, it must be achieved without infringing upon the rights of responsible gun owners.
is of there's simply no rational basis for it in terms of thinking about self-protection.
Democrats actually passed the Safer Communities Act.
For years, the Democrats told us we're not coming for your guns.
And it's almost like a slap in the face to the Supreme Court, just telling them, hey, we don't care what you're going to do.
Critics argue that SB 2's approach tilts the scales too far in favor of restrictions, effectively discouraging individuals from pursuing concealed carry permits due to the onerous requirements and limitations it imposes. The concern is not solely about the immediate impact of SB 2, but also its potential long-term consequences. Striking the right balance between uniformity and individual liberties is an ongoing challenge, and the outcome of this debate will have far-reaching implications for the future of gun rights in California. That's all for this video, folks. We'll see you next time.